Mic check, mic check, mic check. I don't know why my camera doing all this glitching. Y'all, we are waiting on court to resume. Waiting on Lil Woody, my boy. No, that ain't my boy, man, but we're waiting on Lil Woody to get in there. Start witness for the state. Oh, let me cook this tea. Y'all, we waiting on Lil Woody to get back in there. Waiting on court to resume. Our court supposed to start at 9. The judge is always on some bull. Alright, y'all, this is the citizen, man. This is the other guy. I don't know who this guy killed. We shall see how much time he gets. Oh, he's a serial killer. Serial striker. Gotcha. Wade Wilson. That's the guy's name. And then the YSL trial is still on standby, still waiting for the judge to come in the courtroom. start for his day. I can tell you he's already guilty. I can tell you that already.
Okay. So what I'm saying is the courts, there's language in court cases regarding like splitting up, like this number 4 on the bottom of page 1 carries over onto page 2, and it should be all on one page. So either push it to the next page and then make sure that if, in other words, you don't want to have one run over from one page to the other. Okay. All right. I can get you more paper if you need it. I will want, once you get that done, just a complete printout of the final instructions.
Staples.
They don't all have to be on the same page. You just can't have it split in half between 2 pages.
So
I mean,
okay.
I don't expect you to change the font or anything.
So you're okay with, so if you count 1, you're okay with 1 through 3 on one page and then 4.
4 would start next. It was just split between the 2 pages, and I think that court cases say that's not preferred. So.
Yeah, the YSL trial is still on hold. Waiting on the judge to come in.
All right. Is there an instruction on the verdict that goes before the verdict form? No?
No, Your Honor.
Okay.
That's all delineated in the course of the instructions.
I'm sorry, I can't hear you.
I said that's all been delineated in the definite instructions.
Okay.
Mr. Williams, Mr. Steele, Mr. Adams, Mr. Pines, and Miss Haltwinger, good morning. All right, Mr. Kendrick and Mr. Weinstein, good morning.
Good morning.
Mr. Huey and Mr. Matthews, Senior, good morning. Mr. Nichols and Mr. Harvey, good morning. Mr. Ryan and Misty Williams, good morning. All right. Mr. Smith, Mr. Uhalski, Mr. Brown, Mr. Atkins, and Ms. Hilton. Good morning, councils. All right. Okay, so to pick up from where we left off yesterday, Mr. Adams, I have your proposed redactions. I mentioned yesterday, I sent, you were kind enough to send them to Ms. Weaver as well. We marked them as the next court exhibit in order, so we can work off of that. So the first one you have is page 413, line 17 to page 416, line 11. And it apparently is a conversation about a gun, about D buying a gun, whether YT bought the gun from D, and your objection is relevance and hearsay, among other things.
Yes, sir. And with the court's permission, I have had a chance to speak with Ms. Hilton on this morning. That's whether she had reviewed what I sent her the other day.
Okay.
There are a number of these. I think I have a total of 28 specific ones that I've identified, and there are a number of them, probably the majority that we agreed. Okay. Will be redacted, and as we get to them, I'll make that notation on the record. That's okay.
That's fine, sir.
And so the court is correct. The first one that I have, may I keep my seat, by the way?
Yes, you may, sir. As long as you speak in the microphone so everybody can hear you.
Yes, sir.
Okay.
The first one that I have is on page 413 of the transcript, as the court indicated, starting at line 17, going to page 416, line 11. And that is, in fact, where there's a conversation that's being had about a gun, about someone named D buying a gun. And I'm kind of synopsizing the entire conversation over those pages, and whether Mr. Williams bought the gun from D. My position, and let me say this. I'm also comfortable going with the transcript. I indicated to Ms. Hilton earlier, I don't have really much of a dispute. The transcript is for the most part accurate. If the court wants to hear the actual audio and video to compare it to the transcript, I know the court will let us know that. But my position is that those sections contain testimony or statements that are not relevant. They can contain some hearsay, and they contain statements from the witness that is simply his opinion. And for all of those three reasons, they should not be admitted.
All right, sir. Ms. Hilton, what's the state's response as to those particular line and, should say page and line references?
Yes, Your Honor. While I do believe the court should hear the portions of this particular section, Your Honor, and it will begin on page 413 at 411-14.
411-14
Yes, Your Honor.
through.
413-35.
Okay, what's the state's position? I'll decide whether I need to hear it or not, but.
Your Honor, we believe that Mr. Coleman is talking to Dennis from not rumors, but from his personal knowledge about the fact that Quindarius Zachary is purchasing guns on behalf of members of YSL. Quindarius Zachary is an unindicted co-conspirator. Part of the state's theory in a number of instances that Mr. Zachary was a straw purchaser for a number of guns that were recovered by YSL members. Specifically, the one gun that Mr. Coleman has in his possession, matter of fact, the reason for the arrest that brought him into this interview was a gun that Mr. Quindarius Zachary purchased on his behalf. This section talks about where Mr. Zachary purchases those weapons from, and we believe that that is relevant before the jury again going into the overall gang conspiracy in this case. It's not hearsay, it is what Mr. Coleman knows.
And so if I can just respond.
Yes, sir.
Briefly, and.
But I would say we'll like work to play prior to this and you can hear the consequences, because while there is a transcript, there are some things that are indiscernible that I think the court will need to listen to and hear, and not just solely rely on the transcript.
I'm fine with doing that, and then perhaps I'll hold my my commentary until after you've heard it.
Okay, all right, let's play it, please. 411-14 to 413-35.
Y'all can let me know, man, if the sound is good and everything, the audio. Leave him out there with that gun and not claim it.
Leave him out there.
With the gun he got caught with. You said his motherfucker gun. Why he wouldn't come and claim it? But that's his big homie.
I know too why he can't come claim. I thought it was in his name.
Who name?
I thought it was two guns.
That gun ain't in nobody. It's in somebody's name, but it ain't in his name.
Yeah, I did not do it.
Yeah.
Yeah, he had it was. So he had it was.
He had a drum on it. He had a drum on it.
I went.
On that gun. He to let y'all board or the PK on the board.
He gave it.
Why? When you put it over?
No, they told it. Yeah, no, they did, man. They gonna steal it and they gonna run off and all this.
So you give it the D. So why would D do it?
The D got another gun in the name, AK Thug gun.
Really?
Yep.
When did he buy that?
In January.
This past January?
Yeah.
Where he buy it from?
The same pawn shop.
No, sir.
Yes, she did. She got some information. He bought it that AK first to Draco. He didn't buy it from her. Yeah, he bought it from her. Cool all that. He bought a Draco. It ain't from there. It ain't from Arrowhead. Shit, I don't know where he bought it from. He bought it at Punch out. And he bought it from Doug. No, he bought it himself, but sold it to Doug. Yeah, who was jugging. He was buying and selling to him for a high price. So what if y'all find a stolen gun? Y'all still sell it to him? You just tell him it's dirty or something? Nah, he buying whatever. He buying a stolen gun, a jit gun. If I call him right now, still I got guns to get back. Man, buy everything. Just because he got it.
So, again, Your Honor, this isn't Mr. Copeland speculating, he's saying that, and he is aware that, one, Quindarius has purchased guns, two, that he brought it from a pawn shop. Now, even when this, detective
Dennis,
kept saying, it's not from Arrowhead, he said, I don't know about Arrowhead, I know he bought it from a pawn shop. And then further, he goes in to say, no, he bought it from himself and sold it to Thug. We was jugging. It was buy it and sell it to him at a higher price. And so this is not him speculating. This is him talking about purchasing guns. Again.
Were you born between 1979 and 1989? If so, you can get a Milwaukee combo kit completely free. And I can tell you right now, this is going to upset a ton of people because we're giving away these.
Which is YSL, and the fact that they purchased guns is part of the overarching larger conspiracy in which the state is proving here. So this information is one, relevant, and two, it's not hearsay and it's not saying.
have you already asked Mr. Copeland already about guns and the purchase of guns on direct in your direct thus far?
I don't recall if I've asked him about this specifically. But again, the premise remains the same. You know, if Mr. Copeland is, as he said in court, making it all up to, he made everything up in this interview in order just to get out of jail, this isn't something that he's making. This is not something that he is making up. This is something that the evidence will show that the detectives did get, one, they did find that Mr. Zachary had purchased the gun that he was found in possession of. They also got information from Quindarius Zachary about the guns that he purchased. So this is not him making it all up. As he said in court, that everything he said, he was telling them whatever it is that he wanted to say, he's not making this information up. And so,
Oh, why would you think that it could be played before you ask the witness the foundational questions? I mean,
because that's the same reason, it's not private. Again, Your Honor, the premise, the reason why this video can come in.
but I'm only going to let you go so far, okay? I mean, I think you gotta ask some questions in regard to that. I mean, if they haven't been asked, I'm not saying you can't ask, play it. If you haven't asked them already about this, there's some foundation that needs to be played.
Well, we can impeach multiple different ways. The one way is impeachment by contradiction. Another way is impeachment by contradiction.
Okay. All right, I'm not inclined to let you impeach him by contradiction at this point because because he hasn't testified about anything about any guns or anything like that, and you haven't asked him anything about any guns, which is what you just said. So if you had asked him about guns, and then he coupled with the potential not being truthful, you could probably at that point in time the foundation would probably be satisfied. I agree with you. You can impeach him many ways, but I think your foundation is lacking at this point. I'm just saying, if you're going to ask him that you still got him on direct. You can ask him those questions, and then if he denies it or whatever else, then you may be able to get into some of this. So I'm going to exclude it at this point in time, Mr. Adams.
All right. Thank you, Judge. No argument on that then.
Okay.
The next one, Judge, page 419, line 10 through line 11. It's a line where this is the detective talking, suggesting that Mr. William and them is going to find out something about Copeland and, quote, knock your head off. He's talking to Copeland at that point. We've agreed, I've spoken to Ms. Hilton, we've agreed that that should be redacted.
Okay.
And I'll rely on Ms. Hilton to give us the time stamp on the video.
Let's see if we can get that. Ms. Hilton, madam?
4/16/11
Okay.
through 4/16/17.
4/16/11 to 4/16/17.
Yes, Your Honor.
Okay. All right. Continuing on.
Sure.
Go ahead.
The third one, Judge, is contained at page, is pretty expansive, page 421, line 16, goes to page 428, line, I have 16. We've agreed that it should go to 25. So that's going to be 421, line 16 to 428, line 25. That is a conversation, an extended conversation about someone named Kente and about that person having people killed, about Kente and his brother robbing and killing other people. There are numerous references to things said by unnamed individuals, references to persons potentially paying Mr. Copeland to kill someone, references to the relationship between some individuals and Mr. Williams, and assumptions of conversations that would have taken place between various individuals outside of the presence of the witness, Mr. Copeland. We have agreed in my conversation with Ms. Hilton that should be redacted.
Okay.
And as before, I've given the page and line numbers. If Ms. Hilton would be kind enough to give us the timestamp, please.
It'll be 4/18/36 through 4/25/30.
4/18/36.
4/18/36 through 4/25/32.
Okay.
32.
All right. Next, sir.
Yes, sir. The next one we've not agreed on. This is on page 430, line 19 to page 431, line 17. And so in that one, and again, if I can keep my seat, I'll go ahead and
Yes, sir.
I'll read the relevant
That's
parts. There's a male speaker, and essentially it's a conversation about how Mr. Copeland got to know Mr. Williams, and what is said during that part of the transcript, starting at line 17. The male speaker asks, "So how you hook up with Thug and them?" And Mr. Copeland goes on to say, "I had what I had. He wanted some weed. He wanted, I think it says indiscernible. I think it says a zip of gas." Mr. Copeland goes on to say, "And tick, like he pulls and rolling through, he'd come and get weed for him. I get weed for my brother. You feel me? Like he got the weed for $200. It cost $250 at the time."
They tell him everything.
Mr. Copeland goes on to say, we took back up there. When we took it up there, Thug gave me the money for the weed. And then he gave me some money to put in my pocket. Gave Tick some money to put in his pocket. You know what I mean? And then I got around I just blended in and then started kicking with him. And when I started kicking with him and stuff, I think we were shooting pool. We got finished shooting pool and we left. And then out of the blue, he just called and asked for like we knew people that sell lean. You know what I mean? He started calling. He wanted different stuff. And I just knew that people who got Percocet and stuff like that, I used to just go take it to him. Okay, so that's the relevant part. I believe that is, number one, not relevant. And I want to kind of piggyback on something that Madam Prosecutor said earlier. When we were talking about one of the other statements, she said, well, that's evidence of, straw purchase of a gun. My point is, we've got an indictment. We've got an allegation of a conspiracy. And, we can't keep adding to the conspiracy by saying, well, there's something in the transcript or conversation that talks about, him buying Percocet or him buying weed. And so that's part and parcel of the overall conspiracy. It's simply not. there are some things that are just not relevant. I don't believe that, whether or not Mr. Copeland observed Mr. Williams, whether it's true or not, buying or smoking marijuana or buying or ingesting lean or Percocet, that's relevant to any issue in the case. It's certainly not relevant to anything that's charged. No specific indicted offenses, no acts of the conspiracy. So I think it's irrelevant. And I also think it goes to character. I think it's a comment upon Mr. Williams's character to insert that in the trial. It is certainly more prejudicial than probative. It's not probative of anything, quite frankly. No issue that's before the court or before the jury in this case. And so I would ask that be kept out. I simply don't think that it's relevant.
Okay.
And I'm sorry, let me just add to that before Ms. Hilton responds. I did want to address this whole issue because we keep coming back to it. That Mr. Copeland, who is on direct currently, one of the things he said is something to the effect of, I made that up. I made this stuff up. Well, that's not really carte blanche to impeach him with everything that's in his statement. We've already objected on behalf of Mr. Williams, and I think everyone else has, to the recording being played at all. But I just want to point out that she doesn't, if they're attempting to impeach him, you got to kind of pick and choose what you're impeaching him for. And you don't just get carte blanche because at one point he either says, I made that up, because he also said, yeah, I probably said that. You don't get to say we're going to impeach him by just playing everything, and every single thing in his statement is relevant and comes in and is not subject to any other objection. So that's my position on that.
All right. Ms. Hilton?
Thank you. First, I do want to address the impeachment issue, because the idea that we have to now impeach him line by line, I believe that the courts have held that we don't have to teach him line by line, especially when he's telling the court, telling the jury.
I think we covered that already. I mean,
I do want to cite the court to a case, which is Steiner's States.
What is it?
318 Georgia.
What is it, madam? What's the name of the case? 318 Georgia? You said
318 Georgia, 855.
Okay, and what's the name of the case?
Sconyers, SCONYERS v. State.
Okay.
And that's an April 2024 case, Your Honor.
All right.
And here it says, and again, this is focusing on prior inconsistent statements, but I think that it's instructive. In Division 3, near Head Note 8, it says prior inconsistent statements that meet the requirements of Rule 613B are not hearsay if the declarant testifies at trial and is subject to cross-examination. The failure of a witness to remember making a statement, like the witness's flat denial of the statement, may provide the foundation for calling another witness to prove the statement was made. Here, Finch's denials and alleged lack of memory of her prior statements and their contents were a sufficient foundation to allow other witnesses to testify about the content of those statements. That is the argument and the hitting. And it goes on to cite several cases where it cites Murdoch. It says, see Nelms 313 Georgia at 788. See Bridgewater v. State, which the state addressed yesterday, which they cite or quote from Bridgewater. One witness's unambiguous denial that he had ever spoken with a second witness, as well as his assertion that he did not recall ever speaking with him, obviated the need for the prosecutor to ask the first witness about specific statements he made to the second witness and provided sufficient foundation for the state to present extrinsic evidence of such statements. Also citing Murdoch, which was 299 Georgia 177, a witness's prior inconsistent statements about a shooting was properly admitted under Rule 613B after she testified that she could not recall the details of the shooting itself or the content of her statement.
Okay, and stop right there, just if I can hijack you just a second. I don't have any issue with anything you said so far, and I think that you and Mr. Adams coexist in that space. However, the challenge you have is you've got to still ask the question about that area, and then I think it picks up from there. I'm not going to allow you to play it until you lay a little more foundations for that reason. I'm not saying you can't play it, but you still have to give that witness an opportunity to be heard on that particular thing, asking about the gun, asking about that. So I think that what Mr. Adams is telling you and the court, the court kind of has some concern. That's why I asked you yesterday, was it discussed on direct? And you said, well, I'm going to check and see if it's discussed on direct. That's the predicate. So
if I could finish reading the next portion of Scott, I think that addresses the court's issue. Scanners complains of the state's failure to confront Finch with the specific extrinsic evidence of her alleged prior inconsistent statement.
Okay, but you still have to ask him about the topic area.
So I want to get to the last portion. But
okay.
As Bridgewater and Murdoch indicate, Finch's failure to recall making any statement at all about fighting, abuse, or anything like that, as well as her denial of the mall incident, and Scanners arguing with Lincoln relieved the prosecutor of the need to ask about specific statements.
Okay.
So that is where we're focused at. The fact that he says, I made it all up, relieves the state from having to go line by line and asking about specific statements.
I don't have any issue with that. I don't. But I still think you guys, it's not like you have to give the witness an opportunity to confirm or deny. I'm not saying that. But I think as a matter of, you've got to orient the witness and tell him and ask him questions about the gun. You can't impeach him on a gun when you haven't even asked him anything about that. Yeah, you haven't, just based on, well, I don't remember. He hasn't even said, I don't remember anything about it. So, I mean, I think you need to introduce the topic. And then if he says, I don't remember, I don't recall, then you can do that. That's why I'm saying there's foundation and predicate. I don't disagree with the case law that you cited in Sconyers but that's why I asked you has he testified as to that already? If he's testified about that and his memory's kind of, I don't know, I don't recall. Yeah, you can impeach him by prior contradiction or any other means that you think is appropriate under the circumstance. So I just want to make that clear, okay?
Thank you, Ryan. So as it relates to this particular portion of the interview, Mr. Copeland, I believe in court, when asked how did he meet Mr. Williams, said, I met him at the studio. I was kind of like a fan. What this portion of what Mr. Copeland tells the detectives back in 2015 is that this relationship kind of grew. It grew from possibly him being the person who facilitated giving him drugs to a more developed relationship, which was not just a fan. We have pictures of Mr. Copeland and Mr. Williams at each other's homes, or it looks like at their homes or respective places where they live. We have Mr. Copeland and Mr. Williams on tour together. And this evidence about the development of their relationship is relevant as far as
But haven't you gotten testimony about that already from the witness?
No, because he made it seem as though it wasn't a very close relationship. What he said is, I met Mr. Williams at the studio, and I was a fan of his.
Okay, well, how do you justify? I'm sorry, hijack again. How do you justify then talking about him being purportedly Mr. Williams' go-between to acquire, illicit drugs?
So, Your Honor, again, we have charged in this indictment the fact that the members of YSL possess and sell and distribute narcotics. So this talks about that relationship. So this is relevant. This is already in the indictment. This is in the preamble of our indictment, Your Honor. Additionally, Your Honor, citing to two cases, Anderson v. State, 337 Georgia App 739, which is a 2016 case, as well as Moore v. State, which is 295 Georgia 709, which is a 2014 case. Your Honor.
Okay.
In both of those cases, it talks about relevant evidence as well as that evidence which incidentally places an individual's character into evidence. Your Honor, here in this case, there has already been testimony of Mr. Williams being stopped in a car with drugs. So this information with Percocet in 2017, I believe he was also stopped with marijuana inside that same vehicle. So this information about Copeland talking about Mr. Williams and how he met him is not anything that is more substantially outweighed by its prejudicial effect, because there's already evidence before this jury about Mr. Williams being stopped with drugs in his car, being stopped with guns inside the car. So the fact that Mr. Copeland is talking about this is how they met is not substantially prejudicial, and it is relevant to talk about the development of their relationship from being, whether it was his supplier of drugs, to a more developed friendship, which is more than what the witness indicated on the stand. And furthermore, Your Honor, I believe in opening statements, Mr. Steele, when talking about the relationship of Copeland and Mr. Williams, tried to distance Mr. Copeland from Mr. Williams. And I believe in opening statement, Mr. Steele tried to assert that Copeland was more friends with Demekion Garlington, in which they are friends, but really tried to distance what Mr. Copeland's relationship was with Mr. Williams. So I believe that the jury understanding the development of their relationship is important to assess whether or not they find what Mr. Copeland is saying in his 2015 interview credible.
Thanks for the lights. Thanks for the lights.
So, Judge.
And I'm sorry. And I just wanted to cite in Anderson v. State in Division 1, it states that it is well-established evidence that is relevant to an issue in the case is not rendered inadmissible simply because it incidentally puts the defendant's character at issue. And it cites to Jones v. State. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And it cites to 24-4-401. And while relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, exclusion is an extraordinary remedy which the court should invoke sparingly, and the balance should be struck in favor of admissibility. Furthermore, as a general rule, admission of evidence is a matter resting within the sound discretion of the trial court. And appellate courts will not disturb the exercise of that discretion absent evidence of its abuse. So, Your Honor, we believe that it is more relevant for an issue on hand. It is not more prejudicial, substantially more prejudicial than probative, because there's already evidence before this jury of Mr. Williams being in and around or associated with narcotics, Your Honor.
Are you finished, Madam? So I can let Mr. Adams respond. Ms. Hilton, you done with this response?
I may have a vote, Your Honor, after Mr. Adams.
All right, so I'll keep it brief, because I think maybe we sometimes have a tendency to conflate the issue. My objection is really very, very simple. That there's statements from Mr. Copeland about them either smoking weed together or him getting some weed from Mr. Williams or some lean or some Percocet. And my position is that that is irrelevant. That it doesn't go to any issue in the case. The fact that the indictment alleges that members of what they say is a gang were selling or engaging in the sale of narcotics is separate and apart from whether or not someone's smoking weed together. Right? I mean, just keeping it that simple. But moreover, if what they say the issue, what they really want is to get at the relationship. How did Mr. Copeland get to know Mr. Williams? That's what they said the issue is, and they say that this describes it. Well, that's not totally accurate, because I'll do what Ms. Hilton has done to put it into context. There's more in the transcript and in the statement that actually addresses that. If you continue to read over the next page or two in the transcript.
Starting from where?
Starting from page 431, line 19. You see Mr. Copeland saying, after a while, every time I go up there, he had me chill for a little minute and stuff. I never just go up there and then leave. He says chill or something. We carry over to the next page where Mr. Copeland says, and then after that, just started hanging with him. You know what I mean? Started putting my name in his songs and stuff, just like, oh man. Then we started hanging a lot. Skip down a bit. He started taking me places and stuff. I appreciate everything you're doing for me. Like, it ain't no problem. That's how I started hanging. You know, so there really is more in his statement that describes exactly what the state says they're looking for, how the relationship developed, what was the nature of their relationship, without us necessarily having to inject this character evidence about them smoking weed together or getting lean or getting Percocet into the trial. That's simply not a relevant issue. And so the argument, I think, that I hear the state saying, well, there's been other evidence of Mr. Williams being in possession of illegal drugs, and so this doesn't matter. Right? Well, it kind of does. That's like an argument saying, well, if someone is charged with a burglary and there's some evidence or some statements about the person committing other burglaries, that, well, we can let that in because, you know, there's already been evidence about some other burglary. Well, you know, you got to notice the defense if you intend to introduce other items or relevant similar items. You used to call it similar transactions, 404B at this point. But that's my position. I'm trying to keep the issue simple. I think it's irrelevant. I think it injects his character improperly, and I think for that reason. And I also think that what they're looking for is contained in other unobjectionable portions of the statement, and so I'd ask for it to be kept out.
What about, Mr. Adams, let me answer this for me, if you wouldn't mind.
Yes, sir.
What about the issue in the preamble of the indictment where it says, you know, that members possess, let's just say it's just offered for that particular reason? What would your argument be at that point in time? Because it's up to the jury to determine whether or not it's relevant. But I mean, I'll make a threshold determination. But whether or not it goes to anything,
right?
What would you say if I just said, well, it could be potentially admissible if just to show possession of illegal substances by YSL members, purportedly YSL members, because they have to first make that determination. But and then, of course, you know, what it would be used for.
Sure. The preamble, you know, to the indictment is really that's argument, right? What we get to, what they have to prove, and what we have to address is what's actually alleged in the indictment. What's alleged in the conspiracy, in the RICO count, and the specific acts. And we're put on notice by way of specific acts and also by specific indictment numbers. Now, if they want to allege that Mr. Copeland and Mr. Williams smoking weed together at the studio is an act that is part of the overall conspiracy, then they allege it in there. But they haven't done that, because by that logic, really there's a lot of things that are said here by Mr. Copeland that aren't part and parcel of the indictment, but they can make the argument that, well, you know, we said something about drugs in our preamble, and so all of that comes in. And I think that's essentially their argument, which I think does not control here. But my objection is just pretty straightforward, pretty simple. I think that is irrelevant. His character should be taken out. That's all.
Your Honor.
Yes, ma'am, you certainly may.
Your Honor, the YSL organization uses criminal activities to expand their criminal networks. So the fact that Rudy started off as a drug dealer, this isn't about them smoking weed in the studio. What it was is that he was bringing him the drugs, that the fact that he started off as a drug dealer and then was able to get into the gang itself or the organization and become an associate is a parcel of the larger RICO conspiracy. He went from not just the person who supplied drugs, but he moved on to a more associate membership relationship, again, talking about all of the portions that Mr. Adams just cited. So we transitioned from you bring me my drugs to now I have embraced you into our organization. Now you are a member of our organization. Now you can take trips. Now I can give you money in the club. Now you are a part of our organization. And I think that development in and of itself is important and relevant for the jury.
Well, that's a really good argument, and that's something good for closing argument. But that's, you know, and it's fine for them to have a theory, right? But just because they interpret it as such doesn't mean that there is evidence of that. You can't say that, well, him saying that we smoke weed together in the studio is evidence of him bringing him into a gang and them engaging in conspiratorial conduct. I mean, again, the state is fine to have whatever argument they want to have, but the court's determination is whether or not this particular piece of evidence is relevant, and whether or not it impugns Mr. Williams's character by its admission. I think it does, and I think it's unnecessary.
Okay. Court regards to this particular subpart, page 430, line 19 to 431, line 17. Ms. Hilton, what are the corresponding video, audio?
Right, that should be from 427:07 to 428:15.
All right, thank you. The defense argues that this particular period is not relevant, making a 401 issue. Character, it's a bad character and it's hearsay. The state responds and counters that it is relevant to show the development of Mr. Copeland's relationship with Mr. Williams. They cite for that proposition Sconyers, which has been previously cited on the record, Anderson, which is previously cited on the record, and Moore, which has been previously cited on the record. The court's had an opportunity to take a look at those cases, in particular Anderson, and the court is of the opinion that given what the state is proffering that they wish to admit it for, that I'm in concurrence with the defense that it is not relevant for that particular purpose. It shows more the individual drug use or more so than it does indicate in the preamble to the indictment that for the possession, sale, or distribution of obtaining money, weapons, or other property through acts of racketeering, including robbery, theft, and unlawful sale and distribution of drugs. This is more for this, in this particular section, the court is of the opinion that it more so talks about how Mr. Copeland and Mr. Williams started their relationship in terms of the sale, or not the sale, but the acquisition of one by Mr. Copeland to Mr. Williams. I believe that would be more prejudicial than probative under a 403 balancing test. There is other information in this particular transcript or in this particular video, which does show the relationship between the two. And I believe that is more relevant in the circumstances. It doesn't kind of put us in this character issue. Now, you know, this is my ruling on this particular portion of the transcript. If other things come up, or if the door is opened up by any other witness or any counsel's inquiry about this, the court will go back and take a look at that, okay? But right now, I'm going to exclude it.
Thank you, Your Honor.
Okay.
The next one, may I move on?
Yes, yes, sir. Unless there's any other argument by him having anybody else. Okay, go ahead, sir.
436, line 23, page 437, line 15, relatively short passage. That's a portion of the interview where Mr. Copeland is talking about statements made by Mr. Williams' father. Talks about what the father either told him or what the father says he knows, what the father thinks about him, Mr. Copeland, talking to the police. Obviously, Mr. Williams' father is not part of the indictment. I don't believe the state's gonna allege that he is an unindicted co-conspirator. The relevant portion, if we start at line 23 of page 436, just to give the court a flavor of what we're talking about, when Mr. Copeland says, line 23, and this comes on the tail end of the detectives asking Mr. Copeland about whether anyone has an issue with him talking to the police, whether they've ever asked him when he's talking to law enforcement. So Mr. Copeland starts at line 23 saying somehow Thug's daddy, he be with Kente and them a lot. Thug's daddy told me out his own mouth, like he's connected. You know what I mean? I don't know who he's connected with, but he get all this information. He get a lot of information. You know what I mean? He said it out of his own mouth, and he like, you know what I mean? He knows what's going on. That, I'm gonna say N-word, because I think we can go around that word for free. That N-word told me he could change my identity and everything. That's what he told me before beef. Like, and when he said all that, I thought he was just talking. And when I came to Metropolitan, what's the name? He was looking at me crazy. I mean, and then from that day on, been hearing the little story, like I've been talking to the police a lot. You feel me? When I was telling the police, I wasn't telling them about what I should have been told them. I was telling them about what people are doing to me. You feel what I'm saying? So that's where it ends. That whole portion is really what Mr. Copeland is relaying to detectives, either what he heard from, what he knows of, or things said by Mr. Williams' father. Totally irrelevant, and certainly hearsay. And so, for no other reason other than that it's hearsay, well, that's relevant. I'd ask it to be extracted or excluded.
All right, State.
I don't know what it goes to.
Okay. Madam?
Your Honor, I think you need to continue to read the rest of that page, because the portion that Mr. Adams just cited is not out of context with what happens on the rest of the page, Your Honor. So if you continue on, starting at line 16, he says, I didn't want to tell them about my so-called friends at the time. But in the way he was saying, like, I talked to the police a lot, you know what I mean? Like, he knew I wasn't going to tell, but he knew I was talking to him. So I don't know how he get his information. But when he said that, I thought he was just talking at the moment, trying to scare me up or whatever. And so I think that is the most salient line, is that we're not offering it for the truth of the matter asserted, which is whether or not Mr. Williams' father has connections in the street, whether or not Mr. Williams, that's how he gets his information. But the effect on Mr. Copeland's state of mind and the effect on him as the listener, hearing whatever it is that Mr. Williams was saying to him, that's how he interpreted whether or not people knew he was talking to the police and what he was disclosing to the police. And so I think that you have to read all page 436, beginning at line 18, in conjunction with going all the way from page 437 to line 24. So we're not offering it for the truth of the matter of whether or not Mr. Williams Sr. is connected with anyone, but the state of mind of Mr. Copeland as to why he did certain behaviors, why he was concerned about who knew if he was talking to police and what was being disclosed to the police. And again, this goes back to Mr. Copeland's fear of being found out that he had been talking to the police about the homicide of Donovan Thomas.
Well, it really doesn't go to that. You know, it's a response to a question. And what the detectives are asking Mr. Copeland is whether or not anyone knew or asked him whether he was talking to law enforcement. Right?
Well, specifically Thug and Kente.
Right. Yes. If you look at line 8, I think the course is line 18.
Yes, sir. Yes, sir.
Have you ever been questioned by Thug or Kente or anyone else as far as you, have they ever asked you, are you talking to law enforcement? He says, not Kente, but thugs. And then we pick up from what I know. So it certainly is hearsay, because Mr. Copeland is opining, he has given his opinion about whether or not, or asking whether they had asked him about talking to the police, and this is why he thinks so. He talks about what Mr. Williams' father said specifically, what he drew from that, what his opinion was of it. It's really not about the effect on Mr. Copeland, because he doesn't really talk about, well, because Mr. Williams' father said this, I did this. You know, he's really just talking about what Mr. Williams' father said and what he grasped from that, what his opinion was of it. That's not the same thing as the effect on the listener. Right? That's simply his opinion. And there's nothing there to say, as matter, even if you look at the last line, state, that's line 23 on page 437. Actually, it's line 22. He says, he starts saying, I don't know how he get his information, but when he said that, I thought he was just talking at the moment, trying to just scare me up and whatever. Right? It doesn't say that he scared me. It doesn't say that, you know, I did this as a result of what that hearsay statement was. It just says what the person said and what he opines the person was thinking or trying to do. And so it is hearsay. And the truth is, it is being offered for, the state wants it in for the truth of the matter asserted. But it doesn't really go to anything. It's just his opinion.
Your Honor, but that's the key point right there. It is what Mr. Copeland thought as to why he is concerned about people finding out if he snitched or not. So whether or not, again, truth of the matter asserted is that we want the jury to believe that he's connected. I don't know or care if the jury believes if Mr. Williams is connected or not. What the state wants the jury to understand is that this conversation that he had, that Mr. Copeland had with Mr. Williams, informed what he thought about if people are going to know whether or not he told police about the crime, which is the murder of Donovan Thomas, and his concern about that. Truth of the matter asserted would mean that I want the jury to believe whether that Mr. Williams was connected, that I want the jury to believe that Mr. Williams told Mr. Copeland he could change his identity. I don't know if he can change his identity or not. That is not what the state is offering it for. That is offering it for the truth of the matter asserted, that Mr. Williams could actually go and change his identity. I don't think Mr. Williams works for FBI or any other agency that could do that. So why? That's not what we're offering it for, Your Honor. We're solely offering it about Mr. Copeland's the effect that this conversation had on him and the fact that he was disclosing a murder to the police.
So, if what they wanted in for, well, the things they've just said, they want the jury to know that Mr. Copeland is concerned about his name being out there or him being labeled a snitch, or that he is talking to law enforcement. Then it's cumulative because they've already got that. There's already been testimony. I think the jury's already seen a portion of a statement where Mr. Copeland is talking about he doesn't want to be known as a snitch, that he didn't want any paperwork with his name on it. You know, so there's been testimony about that. You've already let that in, right? But what we're talking about here is hearsay, something that Mr. Williams' father purported.
Search Best Credit Cards, and you'll see cards from advertisers. Search Wallet Hub Best Credit Cards, and you'll really see the best credit cards on the market. So if you want to get the best credit card deals, add Wallet Hub to your search.
The industrial grade products you need. Grainger, for the ones who get it done.
He's opining on whether or not anyone knows that he was talking to the police, and based on, and he thinks yes, based on what the hearsay statement is from Mr. Williams' father. But we've already got that. It's cumulative, and so we don't need this hearsay to add to the evidence that's already been admitted.
And Your Honor, I understand that Mr. Adams keeps saying it's hearsay. It is not. And the fact of the matter is, it's not cumulative, because the fact that, and especially in this part of the interview, he is telling a different set of detectives this information. He's actually talking to some IA detectives about information that's not going to come in at this point regarding Officer Beebe. And they're asking him and trying to understand, why are you coming forward now? What is your purpose? And he's beginning to tell them again what he's consistently said in this interview about his concern. And that is important, again, when Mr. Copeland is saying he made all this stuff up in court in 2024, everything I made up, I made it all up. They get to see that his biggest concern was being labeled a snitch. That was one of his biggest concerns in this interview.
I understand that, Ms. I do. I just don't think that this particular section drives home that point. I do agree with Mr. Adams. I think that it's cumulative and it may be the relevance of it is because it really does not go to Mr. Copeland's fear in this particular circumstance. It doesn't. I think there are some other, or him talking about the police, or talking about speaking to the police and his concern being a snitch. I don't think it goes to that. I think he's just communicating third-party information from Mr. Williams' father, and it's not really kind of relevant for the purposes, at least in the court's opinion, as to this particular issue. Having said that, I'm going to exclude it. But again, if somebody opens the door up as to it and lays a foundation as to it, then I may revisit my decision on that. Okay. But right now, I don't think the conversation between Copeland relating about what Mr. Williams' father told him is relevant.
Well, Your Honor, while the state will just ask for a continuing objection, we understand.
You can have it.
We don't believe that it ends at 15 then. We believe that any information regarding any hearsay statements actually stops at line 8
Line 8 of what page, ma'am?
of page 437.
Okay, we'll anybody else want to have any other discussion about that particular edit? If not, and Ms. Hilton, if you would give us the corresponding audio visual time from 436 line 23 to page 437 line 8.
It'll probably be around 432.50
432.50
to 433, approximately 26.
All right. Okay.
We've got a lot of agreements coming up on the next few.
Okay, but Mr. Weinstein's got that my bladder's full look. So I've just been tracking the time, and he just usually kind of, inserts himself right in there. So I'm going to preempt that, Mr. Adams. Can we take 5 minutes, please? Okay, all right. We'll be in recess. All right, thank you.
Page 3. Page 4. Page 5. Page 6. Page 7.
Judge, on page 6, subject to my previous objection. Page 4, I'm sorry.
That's right, on page 6, okay.
No, on page 4.
Page 4.
We discussed it.
The previous objection noted for the record.
Yeah,
Okay.
so one more time, so.
That's fine. And I overrule the objection based on the
Yes, sir.
promulgated standard instructions from the Supreme Court. All right, so then
We were on
page
6.
5, let's go back to, so page 4, I noted the objection. Page 5, any objection?
No,
Page 6, any objection?
no,
Page 7.
no objection.
Page 8.
No objection.
Okay. Page 9.
No objection.
Page 10.
This same objection we had before.
Same objection noted and overruled for the same reasons.
With the exception of that, no objection.
Okay. Page 11.
No objection.
Page 12.
No objection.
Page 13.
No objection.
Page 14.
No objection.
Page 15.
No objection.
Page 16.
No objection.
Page 17.
No objection.
Verdict form, page 1.
No objection.
Verdict form, page 2.
No objection.
Verdict form, page 3.
No objection.
And verdict form, page 4.
No objection.
Submitting case to the jury, page 18.
No objection.
And page 19.
No objection.
Very well. All right. Okay. Yeah. Are we ready to? I know you all probably need a quick break, and then we can start opening arguments. Or not opening arguments. I apologize. Closing arguments. Is that correct? I know. I think somebody requested a quick break, and then we can start. Is that correct?
Yes, sir.
Okay. So let's just take like a 5-minute break, and we'll start with closing arguments.
Gotcha. Camera. Oh, shit. What? Hey, y'all, 5-minute recess in the Young Thug trial. What I'm about to do, I'm about to switch to Kate Coral, the mass killer. They having closing arguments, so that's what I'm about to do. Bear with me.
Person's life. But before we make that ask of you, that ask of the ultimate punishment, I want to go through the evidence, the aggravators and the mitigators, and to remind you why this case is different from others, why these murders are aggravated, and how they stand out from other cases. And as we talked about on that first day of jury selection, there are only certain cases where the state can even seek death, or as the defense said, special cases. An aggravating factor is the only circumstance under Florida law that could result in a defendant receiving the death penalty. And there must be one aggravating factor for each for the state to seek death. And the notice we filed has 4 aggravators and 4 aggravators for the death of Diane Ruiz. And the state only has to prove one to ask for a recommendation of death for each. I'm not going to go through each aggravator at length because my colleague did that in his opening statement, where he reminded you of the details that came out in the trial. And you can review any of that evidence. You can rely on your notes and what you heard in the trial to make your decision about the aggravating factors. But I want to start briefly and go through the aggravators and how we've proved them. Let's start with a capital felony was a homicide that was committed in cold, calculated, and a premeditated manner without any pretense of moral or legal justification. You already found beyond a reasonable doubt that the murders were premeditated through your verdict. You found 2 counts of first-degree premeditated murder. You must now find that that premeditation was heightened, demonstrated by a substantial period of reflection. In order to do that, I think it's important to start at the beginning of this case, where it all happened, off McGregor Boulevard, near College Parkway, at the Buddha Lounge. Music was playing, people were socializing. The defendant went there to have a good time. And he discarded the woman he came with, and he chose one that caught his eye, Christine Mountain. And as he told detectives, this is what I do with women, you know. I use my charm, I use my good looks. That's what I did with the first girl, and that's how I got in her head. And look what happened to her. When the defendant first approaches Christine, he's not threatening. He's smooth, he's charming. He's nice to her and her friend Stephanie. They party together, no red flags, no sign of aggression. He's a fun guy, but he waits. He waits until he's back at her house, in her bed, and Stephanie has gone home. He waits until he is alone with her, until there are no other witnesses. He waits until she is asleep, defenseless. The defendant says she can't get away from him, even if she wanted to, because he's too strong. And when she can't get away is when he kills her, when he strangles her, because he was the lion and she was the prey. But he didn't stop there. He was looking for more prey. He found Diane Ruiz walking in Cape Coral and said, that's the one. You know what? I've already done it once, and I'm going to do it again. He knew there was a school, but he wasn't worried about the school. He wasn't worried that it was daytime, because he got her into his car. He got her alone, and that's when he attacked. He decided he was going to kill her when he saw her walking, and he already knew that he was not going to let her go. He could tell she was getting scared, and he saw her fear. He knew Diane wanted out of that car bad and that she was afraid. He could sense her fear, but what was he? He was a lion, and she was her prey. He had a careful plan. He didn't murder Christine or Diane in front of people. He gained trust. He selected Christine at the Buddha, and he selected Diane as she was walking. He secluded Christine in her own home, and he secluded Diane in the car. And then he tortured and strangled them both. He used calm and cool reflection. He waited to kill Christine. He waited after they had left Jason's home. He waited all night into the early morning hours after Stephanie had gone home. And that's when he killed her, not in the heat of passion, but when she had gone to sleep. He waited for Diane. He waited until he saw the right person. He waited until she was in the car. He waited to reach out and choke her. This wasn't a lover's quarrel. There was no fight. He was calm, and he used cool reflection. The way in which he killed both Christine and Diane was in a cold, calculated, and premeditated manner. The second aggravator is that the capital felony was especially heinous, atrocious, and cruel. The jury instructions define heinous, atrocious, and cruel, and it states that the murder is one which is accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Christine Melton or Diane Ruiz. Strangulation alone is heinous, atrocious, and cruel. Why? Because the victim is aware she is going to die. The victim knows what is about to happen as that perpetrator's hands are wrapped around her neck. And the force that must be used to kill with his hands was significant. Christine Melton was woken out of her sleep. The person she had just partied with, the person she was intimate with, the person that had built her trust, the person she had led into her home, into her bed, had his hands around her neck. But before he killed her, he inflicted torture. He inflicted pain, and he showed utter indifference to her life. We know she suffered before she died because there is evidence she tried to fight him. Her fingernails were broken. Her brain was swollen, and the swelling occurred from blunt force trauma that the defendant inflicted on her before she died. She was covered in bruises. She was bruised on the outside of her body. She was bruised on the inside of her body. She had bruising of numerous internal organs. She had hemorrhaging and bleeding on the outside of her body and hemorrhaging and bleeding on the inside of her body. She had injuries to her head and to her brain. The defendant seemed to enjoy the fact that she suffered, and he told his dad such things. For Diane Ruiz, he pulled her into his car and beat her. He broke her nose. He grabbed her by the neck, choking her, strangling her. He pressed so hard that he broke her hyoid bone and broke her thyroid cartilage. And like Christine, we know too that she fought back. Diane had defensive wounds. She had bruising on her left forearm and the back of her hand. And the defendant said when talking to law enforcement, she was a fighter. I'll give her that. And as he choked and strangled her, applying far greater than 10 to 15 pounds of pressure, she came back to life 3 or 4 times. And as he drove through Cape Coral trying to find a place to deposit her body, she was still alive. And when he pushed her out of that car and she got back up, what did he do? He ran over her.
Wow.
He said he ran over and over her, making her look like spaghetti.
Wow.
She had a laceration under her breast. She had hemorrhaging in the back of the neck, on the spine, and all around the vertebrae of the bones of her spine. And the significance of that hemorrhaging is that there was a significant force that went through that region while she was still alive. And Dr. Coyne is the one that testified to that. Because if she was already dead, there would not have been hemorrhaging in those areas. She knew her attacker was the defendant. She was conscious of her attacker. She was conscious of the beating. And most importantly, she was conscious of her impending death.
Damn.
Not only did she feel pain, ladies and gentlemen, but she was afraid. The defendant testified that he saw her fear, but he wasn't about to let her go. He was going to, and he did inflict a high degree of pain with utter indifference to Diane's suffering. The way in which the defendant killed both of these women was extremely.
All right, y'all, I'm gonna jump back into the Young Thug case slide. But I do want to finish that, so I'm gonna put it on pause. Wow.
To page 5.
Okay, so which one you also gonna agree?
Judge, that would be third from the bottom, page 521, line 20 to page
521, line 20?
Yes, sir. To page 521, line 23 That's where Mr. Copeland references a conversation where supposedly Yak says that Mr. Williams is going to have Tick killed. You've agreed that that should be removed as well. My objection was confrontation, speculation, and hearsay.
And Your Honor, it actually is extended to page 522, line 5.
It goes to 522, line 5?
Yes, Your Honor.
Okay, Mr. Adams, you have concurrence?
I have 1 second.
Yeah, 522, line 5.
Okay, that's, yes, we're in agreement with that. That's fine.
Okay, all right. And what are the time?
So that should be, Your Honor, from 6:03:23
6:03:23?
through 6:03:44.
Okay.
I'm sorry, Ms. Hilton, I didn't hear that. One more time.
Sure, 6:03:23 through 6:03:44.
Okay, thank you.
You're welcome.
By my count, Judge, if are you ready? If the court's ready, it looks like we've got 1, 3, 4. We've got 6. We've got 6 more to.
Okay.
Shut tomorrow.
And then there's the 2 that from Mr. Sharp from yesterday that we need to also kind of bring to closure.
Yes, Your Honor.
All
I
right.
think the state has I'll take a look. The state had a few that overlapped with mine. I'll take a look and be prepared to address that tomorrow.
Yeah, I think all of the ones that the state had for this portion, I believe, are inclusive of what defense counsel asked for.
Okay, so tomorrow, our goal would be to exhaust those 2 or those particular remaining sections, as well as potentially start on the phone calls. Okay? All right. Have you all identified those particular things in the phone calls similarly to the tape that you believe you can share with the defense?
So we've identified the calls. We can get something over to them with the specific portions of
This
it.
is helpful because it kind of just, it narrows the issues. So if you could do that, that would be great. And if you all have corresponding objections, it certainly helps the court in resolving those. Okay?
Yes, Your Honor.
All right. Anything else I need to cover with y'all before tomorrow? We will meet tomorrow morning, starting at 9:30 for an anticipated 10 o'clock start time. And we will we'll be in session till probably, I would say early, I'd say no later than probably about 2 o'clock or thereabouts, okay?
Okay, thank you, Your Honor.
All right, okay. Oh, Mr. Kokomo and Mr. Youssef, I didn't recognize you this morning, but good morning, gentlemen. Okay, all right, we're in recess, okay? All right, see y'all tomorrow.
Did he not just get out of recess? Leave. This man take more breaks. Dang. All right, well, we're going back to Cape Coral now. Dang.
And outrageously wicked and shockingly evil and vile. Both murders were especially heinous, atrocious, and cruel. The third aggravating factor is that the defendant was previously convicted of another capital felony or of a felony involving the use of threat of violence to the person. He didn't just kill one woman, he killed 2. 2 innocent victims, one trying to go out and have a good time, and another just trying to get to work. And the defense conceded in their opening that the state had already proven this aggravator beyond a reasonable doubt. The fourth and final aggravator for each of these victims is that the capital felony was committed by a person previously convicted of a felony and under sentence of imprisonment or placed on community control or a felony probation, You heard from Lisa Lansky, the print examiner, who compared his prints from being sentenced and being placed on probation to the prints that were rolled in court, and they were one and the same. And you also have the certified records and evidence showing that he was on probation at the time of these murders. And the defense in their opening conceded to this aggravator as well. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent to every first-degree murder. The state has met our burden, and we've shown you how we have proven the aggravating factors beyond reasonable doubt. We have proven that this first-degree murder case is an aggravated one. And it's one so aggravated that the legislature has laid out the law that death is an appropriate penalty given the nature and circumstances of these murders. The defendant chose his victims and acted in a way that shocks the conscience of any human who hears the facts and sees the evidence that you saw and heard in this case. The defense presented mitigation during this phase. Anything can be considered mitigating, and you're to consider each of these mitigators. Unlike aggravators, however, where the state's limited by statute, the defense is not limited. However, each of you individually get to decide how much weight, if any, to give to these factors. So I want to go through some of them, and you'll hear when the judge reads the jury instructions, you'll hear all of the mitigators that they've listed, but I want to go through some of the main ones. Let's start, however, with the expert testimony. You heard from Dr. Mills. He testifies solely for the defense in capital cases. And he said on the stand, I was hired to try to help him, not to give an objective opinion, not to conduct testing and to try to find out if he suffers from a mental disorder, but yet he was hired to try to help him. And the only people he helps are defendants. He only works for defense. His testing that he was able to accomplish, the MMPI and the PAI, were invalid because of the defendant's exaggeration. And once those tests were invalid, the defendant refused to meet with him again, refused to provide any additional data. And what was interesting about Dr. Mills is that he discounted the records in front of his face, the evidence that he had before him. He did very little review of the records. And in fact, when I asked him, initially he had said he hadn't reviewed those records. And then on the stand, he said he did review the records. But when I asked who these people were, he couldn't remember. But he gave credence to records that don't exist. He said the hundreds of pages of jail records were basically useless. Yet he relied on the mom's report, which was extremely limited, with no supporting documentation. There was only one evidence of a Baker Act in 30 years. And the Baker Act was because his dad found drugs. And he was released from the facility the very next day. And when I asked him, isn't that unusual, doctor, for someone who supposedly has schizophrenia or some major psychotic disorder to be released the next day? He couldn't say yes. He said, well, maybe his parents don't really remember. Don't you think his parents would remember that if their son was in a mental hospital for an extended period of time? So he doesn't give credence to the Baker Act. To that report, he can't really rely on it, but he's going to rely on other vague things that the parents tell him. He tries to build a diagnosis on two things the parents told him. That there was someone in the garage on one occasion, and that people were looking through the windows. That's the basis of this doctor's diagnosis. He also tries to give credence to there being a major mental health issue and try to say that that mental health issue came first. But when do those changes in the defendant occur? When he's 13. And when do his parents notice these major changes? When he's 13. And what did the defendant tell the investigator? That he began heavy drug usage and got into drugs when he was 13. Yet Dr. Mills discounts the defendant's own admissions and the reason for the Baker Act because they don't fit the narrative of a psychotic disorder. They fit the narrative of substance abuse problems. He discounts the school records. He discounts that the defendant was kicked out of school for selling drugs, not for psychotic episodes. And the defendant also admits that he was kicked out of school for selling drugs to his own investigator. And we had a conversation both with him and with the state's expert about the DSM-5 TR. And it clearly states in there that drug use must be ruled out to make a diagnosis. And that you can't diagnose a psychotic disorder under the circumstances in which Dr. Mills did, because he could not rule out drug use. Nowhere in the records could he find the criteria laid out to support the diagnosis of a psychotic disorder. He had 13 years of medical and mental health records, and there was no specific instances of hallucinations and no specific instances of delusions, and no diagnosis of schizophrenia. And these are some of the things that were required to make such a diagnosis. And the only drug he was prescribed through all these years up until 2022 was for depression, Celexa. And both doctors came up in their SIR rebuttal after Dr. Herkov testified and listed out for you a bunch of medications that could potentially be used to treat a psychotic disorder. But the problem, they weren't prescribed until 2022. And again, nowhere in the records was he even given a diagnosis of a psychotic disorder, not even in 2022. Wow. And I asked the doctors if they had reviewed the emails where the defendant was trying to find out more about drugs, and that drug addicts are often med seeking. They hadn't reviewed those emails. The family's recantation of paranoia and of him believing people are watching him can't be attributed to a mental health disorder, because by the defendant's own admission, he's on drugs, which also is a cause of hallucinations and delusions. Here's a doctor who can't gain cooperation or get information from the defendant, yet he chooses to essentially ignore the case documents. He doesn't review the videos. He doesn't review the tangible evidence from the case, because the problem is the evidence that you heard and saw in this case do not support a diagnosis of a psychotic disorder. And he has to downplay the jail records because they also don't support the diagnosis of a psychotic disorder. You also heard from Dr. Hyman Eisenstein. Now, his background was very limited. He only worked for a rehabilitation hospital for a year, and then he started doing contract work. And in his contract work, he, in the 80s, got involved in a death penalty case and decided that was what was going to become his specialty. And he said that he's testified in over 150 capital cases. How many for the state? None. All on behalf of the defense. And what is a diagnosis in almost all 150 cases? The same. Imagine that. Prefrontal lobe damage. Now, unlike Dr. Mills, Dr. Eisenstein actually spent a lot of time with the defendant. And during that time, he saw no evidence of psychosis, no evidence of delusions, no evidence of hallucinations. And when the defendant reported about mental health issues, it was all in vague generalities. Dr. Eisenstein didn't ask details. And when I asked him, well, what was he hallucinating? What were delusions? He didn't know. He didn't ask, because guess what? He was just there to test his brain, to see if his prefrontal lobe cortex was working, which we already knew was not going to be, given his testimony that he gives in all of these cases. He also kept saying during the defense direct examination that, the defendant had all kinds of diagnoses, all these diagnoses. And when I asked him where in the records he found any kind of evidence of schizophrenia, he said, I misspoke. I didn't find evidence of that. And the problem is his testing didn't say what he wanted it to say, what he tried to make it say to you. He said that this guy scored in the 2nd percentile in regards to his memory. That means, as Dr. Herkov said, only one person in line is behind him. That's how bad. Yet when you look at the case files and the videos and listen to the statements, there is no evidence of memory impairment. In fact, I would submit his memory is actually more than fine. There's also nowhere in the records that suggest his memory is impaired, which would be startling for a 30-year-old to have dementia or some major memory impairment. No signs in the records. And in fact, what do the records say? They say opposite. Dr. Herkoff found in the records where it said his memory was intact. His parents didn't indicate he had problems with memory, and the defendant didn't complain he had problems with memory. And when you see the doctor's own testing results up on the board that Dr. Herkoff showed you, his executive testing and front lobe testing didn't show any damage. Dr. Eisenstein didn't review the case records at all. He knows very little, if anything, about the facts surrounding the murders. And what does he do? Same thing as Dr. Mills. He discounts the records in front of his face and gives credence to records that simply don't exist. He states that the defendant had synergistic brain damage through all of the head trauma. And where does he get this information from? The defendant's father, who indicates he's had some bumps and bruises from playing sports, none of which landed him in the hospital, and none of which required any kind of treatment. And the 2 car accidents, the first one, no treatment, didn't go to the hospital, no follow-up care. And when he went to the hospital in the second car accident, he had a CT scan, it was negative. There were no issues, no bleeding, no problems. The defense attorney, or I'm sorry, the expert, Dr. Eisenstein, tried to suggest that somehow taking a test is significant, that having a CT scan in and of itself is significant. That's like saying it's significant that if a woman takes 20 pregnancy tests and all are negative, that it means something. Taking a pregnancy test doesn't equal pregnancy, and having a CT scan doesn't equal brain damage. In fact, all of the CT scans were of no significance. And his own sister, who's a radiologist, who's trained to read CT scans for a living, confirmed this information to Dr. Eisenstein. So some falls in 2 sports, and 2 car accidents, one in which he didn't even need treatment, led Dr. Eisenstein to the conclusion that the defendant suffers from synergistic head trauma. Again, he ignored the records in front of him and gave credence to records that don't exist. Now, Dr. Herkov, the key difference with him is he works for both the state and the defense. He's not here to give an answer that we want him to give. He's here to review the records and to make a decision not based on emotions, but based on the DSM-5 TR. He used the records. He used the data. He reviewed the videos. He reviewed the defendant's statement. And what did he find? No cognitive impairment, no brain injury, and no criteria that meets a psychotic disorder. The majority of the records contain self-reports, the defendant telling staff his diagnosis, the defendant asking for specific medications, and throughout the records, what are the main complaints? Depression and anxiety, treated by Celexa. 2 likely problems for someone who is incarcerated. You're going to be given the weighing the evidence instruction, just like you were in the first portion of this trial. And it says expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe that person to be an expert. Like all other witnesses, you may believe or disbelieve all or any part of the expert's testimony. And I would suggest that these experts should not be given a lot of credence that the defense presented. You as jurors know more about this case than any doctor who evaluated Wade Wilson does. Neither of the defense experts read through the discovery or read through the witness statements, or very many of them. You are the ones who sat and listened to 28 witnesses. You're the ones that saw the evidence. You're the ones that held the pictures. You're the ones that know what happened in this case. You saw the body cam of the defendant and how he was acting after the murders. You heard his dad testify about how the defendant killed Christine Melton and Diane Ruiz. And you heard the defendant's statement to law enforcement confessing to the murders. It's not credible that mental illness caused the defendant to murder Christine Melton and Diane Ruiz. He was under the influence of power, of lust, of control, of hate. He showed utter disregard for women and for life. The reason for the defense's expert is because most of their mitigation revolves around mental illnesses and drug use. So let's talk about a few of those. The first is that Wade Wilson experienced the following mental health disorders: schizophrenia, schizoaffective disorder, delusional, paranoia, social adjustment disorders, hallucination, and preservation. Again, the evidence in this case points to the defendant being addicted to drugs and that his addiction was the source of his problems, not a serious mental illness like schizophrenia or schizoid affective disorder. Certainly he was depressed at times and anxious, but almost everything in his records are self-reported with very little evidence of symptoms that would support such a diagnosis. Another mitigator the defense has listed out is that while Wade Wilson was on drugs, he's out of his mind, on a rampage, makes him crazy, and makes him do wrong things. Contrary to what we see in this case, he was the life of the party that night. He was having a good time, talking to women, making his rounds around the Buddha, listening to music, drinking. He drove to the Buddha that night in an $80,000 car with his girlfriend. He ditched her and meets another girl. He picks her. He's not out of his mind. In fact, he says that 9 times out of 10, this works to get him what he wants. Girls fall for him. He chose Christine. And the only evidence of drug use from that night was a line or two of cocaine. He wasn't on a rampage. He was cold and calculated. Stephanie Johnson didn't see him acting out of the ordinary. She didn't see him out of his mind, on a rampage, acting crazy. Jason Shepard didn't see the defendant out of his mind, on a rampage, acting crazy. Stephanie left at 6 a.m. that morning. No red flags. Everything was fine. Checked in with Christine. You good? Yep, she was good. He did wrong things, all right, but he was and he is fully responsible. He knows what he was doing, and he thought about what he was doing. Another mitigator they list out is the drugs that Wade Wilson took that night before the event led to an unanticipated effect. The mitigator is virtually the same as the one I just went over. But don't let this mitigator be a suggestion of some other drug take away from what you know the facts to be. There's no evidence of him taking any drugs other than the cocaine prior to the murders. In fact, there's no evidence of him taking any drugs after the murders. You see how he parks his car at Mateo Graphics. He backs into the spot perfectly. You see, and you heard how he speaks with law enforcement. He engages with them. He denies the battery. And then when he realizes he's going to be detained, what does he do? He takes off. And then you also hear how he speaks to law enforcement 3 days later. He speaks the same way as he does to his father. Another mitigator the defense has listed is that Wade Wilson confessed to law enforcement to do the right thing. Ladies and gentlemen, there was no doing the right thing by this defendant. There was no evidence in that statement that you heard that showed any kind of remorse or desire to just help. There was nothing in his confession that he was doing it out of the goodness of his heart to help the police. He wanted a hamburger and fries. He mentioned that over and over. And he wanted to be in general population instead of isolated by himself. Another mitigator that the defense listed was that Wade Wilson tried to reach out to his biological parents when he became an adult. Why did he do that? He wanted money from his dad. Remember, his dad testified he always wanted something when he contacted him. It was always about the defendant, always what he wanted, what he could gain. That's what this whole case boils down to. It's about him. And why did he reach out to his dad again in this case? To hide him from law enforcement, to get him out of town. Many people, ladies and gentlemen, suffer from drug addiction, but they don't go out and commit murders. Many people suffer from mental illnesses, but they don't go out and commit murders. Many people are adopted, but they don't go out and commit murders. I would suggest that none of this mitigation None of these mitigators explained what happened on October 7th of 2019, and that you should give them very little weight. So you are now at the point where you have heard and seen all the evidence of the state's aggravators and the mitigating circumstances presented by the defense. And if you all find that the state proved one aggravator and the defense a mitigator by the greater weight of the evidence, you must weigh whether those aggravating factors outweigh any mitigating circumstances that the defendant proved by a greater weight of the evidence. So what is it exactly that we're asking you to weigh? We're asking you to weigh the curtain rod that was used as part of the torture, that has her blood on one end and Wade Wilson's DNA on the other. We're asking you to weigh how the defendant met Christine Melton, how she looked when he met her, with how he left her. We're asking you to weigh the large number of bruises to her body. We're asking you to weigh her swollen eye. We're asking you to weigh the cuts around her mouth and her eye. We're asking you to weigh the bruising all over her torso, the bruising all over her arms. We're asking you to weigh the blunt force trauma. We're asking you to weigh the significant hemorrhaging on both sides of her neck. We're asking you to weigh the bruising of her lungs, the bruising of her liver, the bruising of the back of her bladder, the bruising to her colon, the significant force to her abdomen. We're asking you to weigh the injuries around her scalp and around her head. We're asking you to weigh the swelling of her brain. We're asking you to weigh his hands around her neck, not being able to breathe, taking that last breath, knowing it would be her last. We're asking you to weigh the cold, calculated, and premeditated way in which he murdered Christine Melton. To weigh how he picked her out from all the ladies at the bar that night, how he flirted and got her to her house, waiting until no one was around, waiting until she was asleep, his hands around her neck, not being able to breathe. We're asking you to weigh the heinous and atrocious and cruel way in which he killed Diane Ruiz. Diane Ruiz, who was simply walking to work. How he met her and how he left her. We're asking you to weigh her fractured nasal bone, the laceration under her left breast. We're asking you to weigh the hemorrhaging and the skin on the left and right sides of her body. We're asking you to weigh the bruising on her left forearm and the back of her left hand, the bruising on her right arm and the fracture of her finger. We're asking you to weigh the hemorrhaging to her neck, her broken hyoid bone, her fractured thyroid, her fractured ribs, fighting her until she was dead. We're asking you to weigh him running her over with a car. We're asking you to weigh the cold, calculated, and premeditated way in which he murdered Diane Ruiz, picking her up while she's walking down the street, sensing fear, not letting her go, getting her in to his car, secluding her. We're asking you to weigh the fact that he was on probation when he committed this crime, and to weigh the fact that he killed both of these women within hours of each other. We're asking you to weigh all of these things and any other facts you may have heard in this trial that support each of these aggravators to the very little mitigation in this case. This isn't about numbers, it's about weight. And what weighs more in this first-degree murder case? In these murders, in the murders of Christine Melton and Diane Ruiz, the aggravators are so much heavier, so much more than any mitigation presented by the defense. And so now is the time that we make that big ask. We ask that you make that hard decision, that you recommend the ultimate crime, punishment for the ultimate crime committed by this defendant. Christine Melton and Diane Ruiz on October 7th of 2019. Thank you.
Give it a minute, Mr. Shirley, let her get it back to the clerk. You may proceed.
Thank you, Your Honor. May it please the court, counsel. Wow, how do we even follow that up? We followed it up with truth. First of all, on behalf of myself, my colleagues, most of all, Mr. Wilson, thank you for your participation. That's probably not the right word. We're asking you to vote to save Mr. Wilson's life. That's a lot more than just participation. That's probably the worst dilemma you may have to face in your entire life as to whether or not you vote for life or you vote to recommend death for Wade Wilson. The judge started this off with an instruction, and I ask that you refresh that instruction in your mind. As counsel and I try and make our points, we may say things to you that differ from what you heard from the stand. We'll talk about that in more detail as it relates to Dr. Mills and some of the other doctors that testify. Nevertheless, you have to rely on your memory, on your notes, on the collective memory of each and every one of your fellow jurors, because you're going to have to go back there and deliberate, and you're going to have to discuss these things. Let me start with addressing the state's mitigating factors. We already told you the reason that they're factors in that circumstances is because they have to be proven beyond and to the exclusion of every reasonable doubt. Well, the problem with two of the factors are we have to believe Wade Wilson's statement to law enforcement on October 10th, because that's where the state gets a lot of their facts from. I will tell you that there are two mitigating factors that we agree they've proven beyond every reasonable doubt. One of them is because of the multiple deaths. That's a gimme, that's a freebie. The other is the fact that Mr. Wilson was on probation on or about the time of the event. So those are freebies, we're going to call them, and they're going to be given whatever weight you think that they deserve, which I submit to you isn't much. The other thing I want to point out before we get rolling here is if I say anything during my closing that you think is a criticism of your decision in the first part of this case. It's not. And I want to explain, we've gone into all this mental health mitigation. We're not trying to excuse Mr. Wilson's conduct on October 7th. That's not what this is about. But we are trying to show you what kind of person he was and why he was that kind of person on that date alone, and why he doesn't deserve your recommendation for death. Let's start with cold, calculated, and premeditated. Ms. Melton. Now, the state told you just a minute ago, well, you know, he was partying, he was having a good time, he was doing cocaine. When was he doing cocaine? And do we know that he was actually doing cocaine? Or was he doing what he told you later was, maybe it was fentanyl, maybe it was flakka, maybe it was bath salts? He doesn't know, because he's never had a mental health experience from taking controlled substances like he did on October 7th. And when did he actually take those controlled substances? It wasn't before he went out and partied. It was after they went over to Mr. Shepard's house. Because if you recall Mr. Shepard saying, well, I had my own cocaine. Well, if you were using your own cocaine, what did you give Mr. Wilson? Mr. Wilson was okay from 2 to 4 there at Mr. Shepard's house. He and Ms. Melton are doing what adults do on occasion. That's their own private business. Eventually, they had to leave the residence. Now, how is Wade Wilson planning all this? We're going to go to this residence, we're going to leave this, we're going to go to this residence. How is that part of a grand scheme of anything? Well, it's not. It's circumstances happening. So they leave Mr. Shepard's, they would go over to Ms. Melton's with Ms. Johnson. Was that part of the plan for Ms. Johnson to come along? Now, oh my gosh, I'm going to have to wait now till Ms. Johnson leaves before I murder Ms. Melton? No, that wasn't a plan at all. There was no plan. He was freewheeling. He was having sex with this willful participant. He was having a great time. In his statement to law enforcement, he tells them there was no planning. After Ms. Johnson left, all of a sudden something came over him and he strangled Ms. Melton. Now, we're talking about all the pain and suffering and everything else that Ms. Melton felt. We don't know any of that. We know that there are injuries. We know that he suffocated her at asphyxia. I can't even pronounce it. But he choked her to death. He put the big hands around her. He cut off her blood supply through her carotid arteries, and she stopped breathing. I asked their medical examiner, was she even conscious at the time that she died? He goes, I don't know. I can't tell you that. He couldn't tell us that about either of the victims. He wraps her up, and he's going to take her and hide her someplace. But it's getting too light outside. And according to his statement, if you believe his statement, she was too heavy to pick up. She was too heavy for him to pick her up and put her in the trunk? Or was it just getting too light outside? Or what is the truth? We don't know. But the state's trying to tell you that all of this stuff in here is the truth. And it's not. cold, calculated, and premeditated as it relates to, wait a second here, as it relates to Ms. Ruiz. Well, he went over and he had an altercation with his girlfriend, come back in the car. Then he's just out driving around. He's out driving around and he stops and asks directions. At some point in time, when did he make a decision that she was going to be a victim? She climbs in the car, they drive down the road, and all of a sudden, he snaps again, and he reaches over and chokes her. We don't really know where this occurs because the questions they asked of Mr. Wilson on the 10th aren't very probing. All we know from Mr. Wilson is that she wanted to get out of the car. He reached over and choked her. He drove her someplace. He opened the door, tried to push her out of the vehicle. When she hit the ground, all of a sudden she got up. At one point in time, he says one time. At one point in time, he says 3 or 4 times she was a real fighter. Is any of that true? We don't know. Is it all reflected in other forensic or physical manifestations? Some of it may be yes. Some of it may be no. Obviously, if he ran over her 10 or 20 times, that's cold and calculated. That's where she was found. Let me get out of the way so you can see the picture. That's where she was found. Do you see tire tracks in that photograph that would substantiate him running over her 10 or 20 times? The clothing is still on her. Does that substantiate him running over her 10 or 20 times? No. Why? It's a lie. He's embellishing. Why is he doing that? Who knows? He's sick. He's got a diseased mind. We can't relate to that. It's hard for us to know what's going through his head when he's talking to law enforcement. Going back to the drugs. In his statement, it must have been like bath salts or flakka. It just made me lose my effing mind, and it made me effing get crazy. When I'm sober, I'm actually a decent guy, which is what everybody else said. Whatever that dude had me on, like fentanyl, flakka, whatever the F it was, dude, it was not cocaine. I thought it was different, and he gave me a lot of it. That shit had me up for 2.5 days. Once again, that's not an excuse for doing what he did. I just want you to understand what his state of mind was when he was going through these events on October 7th. And that person is not Wade Wilson. And that person does not deserve your recommendation for death. Heinous, atrocious, and cruel. Once again, I'm not going to repeat what I just told you about cold, calculated, and premeditated because it applies to heinous, atrocious, and cruel. Now, even the prosecutor told you that is not the aggravating factor. The aggravating factor is especially heinous, atrocious, and cruel. Well, he strangled both these women to death, all right? Strangling in and of itself is heinous, atrocious, and cruel, according to the state. So it would be much better if he walked up and put a bullet in the back of her head because she didn't see it coming, or stabbed her to death from behind because she didn't see it coming. Not all homicides are especially heinous, atrocious, and cruel. And when your medical examiner gets up there and he says, I can't tell you if she was conscious when she died. Well, if she wasn't conscious, then she wasn't experiencing the pain and the panic that the state wants you to believe. Now, we subjected you folks to 3 gentlemen who have degrees that presumably we don't have, who got up on the stand yesterday and talked about mental health. There are other mitigators. The state went through the mitigators. Some of them have been proven to you. I'm not going to go through all those mitigators. I will tell you that the initial mitigators, and this isn't the whole list. You may have the rest of the list on your legal pads there. You may have taken something down about Wade Wilson that's important to you, that's important for you to consider as to whether or not you're going to recommend that he die. But this is a partial list. And part of the partial list is when Wade Wilson is not on drugs, he is charming, he's polite, he's cool, he's in a good mood, he's friendly, and he's outgoing. Well, who was that on October 7th? That wasn't Wade Wilson. Not according to the people that know Wade Wilson. This isn't his family. This is the people that were with him. This is the people that know him. That's how they described him. Wade Wilson confessed to law enforcement to do the right thing. Wade Wilson wanted to put Ms. Ruiz back with her family so they could bury the body. That's what he told law enforcement. Well, the state wants you to believe his recitation of what happened is factual, but that isn't. So, what do you believe out of Wade Wilson's statement, and what don't you believe? You got to be hard pressed to want to vote for death when you don't even know what the truth is. Our doctors, they all have different qualifications. The state first addressed Dr. Mills and basically brushed his testimony under the rug. Dr. Mills has been a psychiatrist for almost 50 years. Dr. Mills was the director of the largest mental health facility in North America with thousands of employees, hundreds or thousands of doctors working under him. That deserves your respect. Now, he would like to have had a lot more evidence, a lot more contact with Wade Wilson, but that was not to be. So I threw him up on the stand and kind of hung him out to dry. Well, you didn't have a lot of time with him, no. But the time he had with him, he figured Wade Wilson out. What else did he use? He used the documents, presumably the same documents that Dr. Herkov looked at, and he came up with diagnoses in those documents. Now, we didn't have a lot of the documents that we'd like to have had. You heard there's a fire at his parents' home, and all those documents from when he was younger are gone. What we had is what we had. But what was interesting was the last thing you heard yesterday. After Dr. Eisenstein had told you when he reviewed the records, there were many examples of medication that were provided to Wade Wilson as recently as 2022 or 2023. And then Dr. Mills got up there and told you what they're for. They're not this sissy stuff that Dr. Herkhoff testified to. They're the real thing. They're antipsychotic drugs. They're there to help treat the psychotic disorders that are listed amongst our mitigators. You can't just ignore that. Now, I think half of Dr. Herkhoff's testimony was all about him. What did he do? Well, he looked at some of the state's evidence. He looked at some videos of Wade Wilson when he gave a statement and Wade Wilson when he was in the vehicle. And he didn't see that Wade Wilson exhibited those disorders while he viewed it, those two relatively short videos. But he went through the records. Like I said before, presumably the same records everybody else had the opportunity to look at. And he didn't find any examples of either medication or diagnosis. Dr. Mills did. Dr. Eisenstein did. But in all fairness to Dr. Herkhoff, he didn't have the documents very long. And I submit to you, he just missed it. He said he went through them in an hour or two. I don't know how you go through a stack of papers in an hour or two and expect to find anything, but that's what he told us. So we're going to let him off the hook. Dr. Eisenstein, but he was very helpful on two things. Dr. Eisenstein spent the most time with Wade Wilson. Dr. Eisenstein put Wade Wilson through several tests. Let's see. What Dr. Eisenstein, what Dr. Herkhoff did was take the tests that Dr. Eisenstein performed, take the raw data, and he made little charts that we got to look at yesterday. And I agree. On certain things, Wade Wilson is normal. He even was the top of normal, of average, in a couple of things. But there were some of the tests where we talked about memory. Tests that would have been important to know those results before we take his statement for granted. Auditory memory number 1, auditory memory number 2, perceptual reasoning, visual memory 1, visual memory 2. All 5 of those tests, he was anywhere from the bottom 5 to the bottom 2%. Only 4 people or 1 person was worse than he was. Executive functioning. Well, on 3 of those, he was fine. He was fine. 4 of those, I'm sorry, I don't want to mischaracterize. On 4 of them, he was fine. He was anywhere from 25% to 50%. He's still in the bottom half. But on the WCST-PR test, he was in the bottom 1%. It doesn't get any lower than that. As a matter of fact, it was probably below that because Dr. Eisenstein told you it was 7 deviations below average. And it was almost negligible as far as trying to calculate his result. And the Dallas Kaplan executive functioning, he did real well on most of them. But on VF category and VF switching, he was either the bottom 5% or the bottom 3%. There's something wrong with his brain. It doesn't work like everybody else's does. Do we know exactly what's wrong? No. Why? Because we only have some CAT scans that don't tell us very much. It tells us if we have a cracked skull. It tells us if there's bleeding under the skull. Well, what do we need? We need PET scans. We need MRIs. Do we have any of those? No, we don't. So you want me to sit here and tell you exactly what's wrong with Wade Wilson? I can't do it. But there's something terribly wrong with him. Now, drugs. Well, you know, just because you're a drug addict, we're not going to not consider the death penalty because you're a drug addict. It's not that he's a drug addict. He took drugs. He started taking drugs at 13. What drugs he's taken over his lifetime, we're not sure. What's the frequency that he's taken the drugs over his lifetime? We're not sure of that either. All we're sure of is that night he was given drugs. What drugs, we don't know. But one of the gems from Dr. Herkov yesterday, as an example, if you have a disorder and you feed that disorder, just say cocaine, what does that do? That amplifies the problem. Well, what if it's another drug? What if it's one of these synthetic drugs that Wade Wilson complained of? What does that do to Wade Wilson when he has a mental health issue? Well, he took it himself. I know he took it himself. You're not rewarding him. You're just trying to decide if you want to take that guy who's cool, who's polite, who's charming, who's friendly, who, in his own words, bucks up one night and does that. I'm going to go back, and I apologize for going in reverse on something here. But, you know, one of the troubling things in the allegations is the fact that he ran over her. We've already discussed the fact that we can't see all these tire marks and stuff from where he ran over her all these times. But we do have law enforcement agency. They were at work, and what did they do? They seized the black vehicle that he was riding around in. And what did they do? They took a swab inside and found blood that belonged to Ms. Ruiz. But what else did they do? They swabbed the front of the vehicle. Okay? And we heard testimony about what they got from, oh, we didn't. We didn't hear any testimony, did we? Why? Because law enforcement agency didn't bother to send that swab off. Didn't bother to get it tested. A piece of evidence that you could have had, that you didn't have, that would have supported the state's contention that Mr. Wilson is telling the truth on October 10th, and you don't have it. I'm not going to bore you with a lot more argument here. You people have a hard enough time in front of you. But there's just a couple of things I want to stress. I mean, somebody in their right mind, he kills a woman, leaves her in her home, because it's getting too light outside. So then he goes to see his girlfriend. And he attacks his girlfriend in broad daylight in front of a bunch of witnesses. Then he leaves. And it's still broad daylight, and he goes riding down a road and picks up Miss Ruiz and later kills her. Does that make any sense? You know what else doesn't make any sense? That's Wade Wilson in October. That's Wade Wilson now. Who in their right mind does that to themselves? He's not in his right mind all the time. And it's worse when you throw drugs on top of it. When he was a little boy, what did he do? They found him wearing a long sleeve shirt with the shirt stapled to his arms. This isn't something that just occurred overnight. This is something that's been growing in Wade Wilson for a long, long time. Now, we heard from relatives of both Ms. Melton and Ms. Ruiz, and I'm sure that there were more that may have wanted to come up, and they wanted to tell you about their loss. We can't fix their loss. They have a hole in their heart. And the only way you can fix that hole in their heart is with love and friendship and fellowship and companionship, and hope that it shrinks the hole in their heart. But you can't fill the holes in their heart with another body. We can't bring these ladies back. There's nothing that you can do to fix that problem. But you can do the right thing here today. I want to, let me see here. Too many papers. Bear with me a second. We have an exhibit. That exhibit's in evidence. And I'm certainly not going to read the whole thing. You've been very attentive and very patient with me, and I appreciate that. For many years, we held on to the hope that nurture would overcome genetics. He was a wonderful kid, kind to animals, kind to those smaller than himself, and loving to his family. But there are many things in life that are out of our control, and it wasn't enough. Wade, like his birth mother, became a victim of his diseased mind. Know that he did not choose this, not any of it. He fought hard against the genetic pull of mental illness and drug abuse. But the man before you is fallible, and he is human, and he lost that fight. As his family, we knew the happy and loving child that he was. The boy who wanted to spend time with his parents and sisters, the one who played sports and loved to read. That person would never do the things he has done. That boy is still in there somewhere, but is now overtaken by the monster of disease and addiction. There's a concept. It's not a concept, it's a gift. That each one of us has the potential. It's something that makes us different from everything else in the animal world. It's a concept known as mercy. When you were selected to sit on this jury, we talked about the jury instructions and those types of things. And the primary theme here is you do not have to vote for death. There's nothing to suggest that you have to vote for death. If the aggravators outweigh the mitigating circumstances, you still don't have to vote for death. But Mr. Shirley, he didn't show either one of those women mercy on October 7th. That's because the monster that he was on October 7th was incapable of mercy. You are not that monster. You are capable of it, and you need to exercise it on those few occasions you have in life when you have the power to do so. We can't love him less because madness has taken him from us. Lock away the monster, but show mercy to the boy inside who didn't choose this path. Know that boy is still in there somewhere, and he is still loved. Lock away the monster.
Members of the jury, you have heard all the evidence and the argument of counsel. Now you must decide whether the defendant should be sentenced to life in prison without the possibility of parole or death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving a death penalty. An aggravating factor increases the gravity of the crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must not consider any other facts as an aggravating factor other than what has been alleged and proven by the state beyond a reasonable doubt. The aggravating factors alleged by the state in count 1, first-degree murder of Christine Melton, are: 1. Wade Wilson was previously convicted of a felony and was under sentence of imprisonment or on community control or on felony probation at the time he committed the first-degree murder in this case. 2. Wade Wilson was previously or contemporaneously convicted of another capital felony or a felony involving the use or threat of violence to another person. A. The crime of first-degree murder is a capital felony. B. The crime of first-degree murder is a felony involving the use or threat of violence to another person. 3. The first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Christine Melton. 4. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim or justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. You've heard evidence about the impact of this murder on the family, friends, or community of Christine Melton. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Christine Melton's death. However, you may not consider this evidence as an aggravating factor. The state has the burden to prove an aggravating factor beyond a reasonable doubt. a reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence the return an aggravating factor if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each alleged aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proved by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty and your deliberations are complete. If, however, you unanimously find that at least one aggravating factor has been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must consider additional matters to determine whether the appropriate penalty should be life in prison without the possibility of parole or death. First, each of you must determine whether any mitigating circumstance exists. A mitigating circumstance is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not appropriate in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances need not be proven beyond a reasonable doubt. Instead, the defendant need only prove a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it proven and give that evidence such weight as you determine it should receive. You need not reach a unanimous decision about whether the defendant has proven the existence of a mitigating circumstance. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances for each of you, each count you may consider are: 1, when Wade Wilson is not on drugs, he is charming, polite, cool, good mood, friendly, and outgoing. 2, Wade Wilson experienced the following mental health disorders: schizophrenia, schizoaffective disorders, delusions, paranoia, suicidal adjustment disorders, major depressive disorder, hallucinations, and perseveration. 3, while Wade Wilson was on drugs, he is out of his mind, on a rampage, makes him crazy, and makes him do wrong things. 4, the drugs that Wade Wilson took that night before the event led to an unanticipated effect. 5, Wade Wilson confessed to law enforcement to do the right thing. 6, Wade Wilson wanted to put Ms. Ruiz back with her family. 7, Wade Wilson is loved by his adoptive parents and sisters. 8, Wade Wilson felt abandoned by his biological parents. 9, Wade Wilson's mental illness started as a child. 10, Wade Wilson was involuntarily committed when he was a teenager. 11, Wade Wilson tried to reach out to biological parents when he became an adult. 12, Wade Wilson's biological parents were young and did not try to reach out to establish a relationship. 13, Wade Wilson was a loving son before mental health disorders. The final step in the process is for the jury to determine whether the defendant should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must weigh all the following factors. 1, whether sufficient aggravating factors exist, and 2, whether the proven aggravating factors outweigh the proven mitigating circumstances. The evidence that you have heard throughout the guilt and penalty phases of this trial should be considered as to each of the capital felonies for which you have found the defendant guilty, count 1 and count 4 of the indictment. However, in making your determination, you must consider whether the state has proven each aggravating factor beyond a reasonable doubt with respect to each capital felony individually, and you must not let your verdict as to one aggravating factor affect your verdict with respect to another. Likewise, you must not let your verdict as to aggravating factors in one count affect your verdict as to the aggravating factors in the other. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance. Regardless of the results of each juror's individual weighing process, if you conclude that the sufficient aggravating factors outweigh the mitigators, the law neither compels nor requires you to recommend that the defendant should be sentenced to death. If fewer than 8 jurors vote for the death penalty, the court must sentence the defendant to life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. This recommendation is not binding on the court. However, I am required to assign and give great weight and deference to your recommendation. You will be provided a form to reflect your decisions. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your decisions. The aggravating factors alleged by the state as to count 4 first-degree murder of Diane Ruiz are: 1. Wade Wilson was previously convicted of a felony and was under sentence of imprisonment or on community control or on felony probation at the time he committed the first-degree murder in this case. 2. Wade Wilson was previously or contemporaneously convicted of another capital felony or a felony involving the use or threat of violence to another person. The crime of first-degree murder is a capital felony. The crime of first-degree murder is a felony involving the use or threat of violence to another person. 3. The first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that would show the crime was conscienceless or pitiless and was unnecessarily torturous to Diane Ruiz. 4. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim or justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. You have heard evidence about the impact of this murder on the family, friends, or community of Diane Ruiz. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss of Diane Ruiz's death. However, you may not consider this evidence as an aggravating factor. The state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each alleged aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your deliberations are complete. If, however, you unanimously find that at least one aggravating factor has been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must consider additional matters to determine whether the appropriate penalty should be life in prison without the possibility of parole or death. First, each of you must determine whether any mitigating circumstance exists. A mitigating circumstance is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not appropriate in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. A mitigating circumstance need not be proven beyond a reasonable doubt. Instead, the defendant need only prove a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it proven and give that evidence such weight as you determine it should receive. You need not reach a unanimous decision about whether the defendant has proven the existence of a mitigating circumstance. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances for each count, you may consider are: 1, when Wade Wilson is not on drugs, he is charming, polite, cool, good mood, friendly, and outgoing. 2, Wade Wilson experienced the following mental health disorders: schizophrenia, schizoaffective disorders, delusions, paranoia, suicidal adjustment disorders, major depressive disorder, hallucinations, and perseveration. 3, while Wade Wilson was on drugs, he is out of his mind, on a rampage, makes him crazy, and makes him do wrong things. 4, the drugs that Wade Wilson took that night before the event led to an unanticipated effect. 5, Wade Wilson confessed to law enforcement to do the right thing. 6, Wade Wilson wanted to put Ms. Rees back with her family. 7, Wade Wilson is loved by his adoptive parents and sisters. 8, Wade Wilson felt abandoned by his biological parents. 9, Wade Wilson's mental illness started as a child. 10, Wade Wilson was involuntarily committed when he was a teenager. 11, Wade Wilson tried to reach out to biological parents when he became an adult. 12, Wade Wilson's biological parents were young and did not try to reach out to establish a relationship. Wade Wilson was a loving son before mental health disorders. The final step in the process is for the jury to determine whether the defendant should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must weigh all of the following factors. 1, whether sufficient aggravating factors exist, and 2, whether the proven aggravating factors outweigh the proven mitigating circumstances. The evidence that you have heard throughout the guilt and penalty phases of this trial should be considered as to each of the capital felonies for which you have found the defendant guilty, count 1 and count 4 of the indictment. However, in making your determination, you must consider whether the state has proven each aggravating factor beyond a reasonable doubt with respect to each capital felony individually. You must not let your verdict as to one aggravating factor affect your verdict with respect to another. Likewise, you must not let your verdict as to aggravating factors in one count affect your verdict as to the aggravating factors in the other. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance. Regardless of the results of each juror's individual weighing process, even if you conclude that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to recommend that the defendant should be sentenced to death. If fewer than 8 jurors vote for the death penalty, the court must sentence the defendant to life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. This recommendation is not binding on the court. However, I am required to assign and give great weight and deference to your recommendation. You will be provided a form to reflect your decisions. The fact that the jury can make its decisions on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your decisions. Weighing the evidence. When consider aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, did the witness's testimony agree with the other testimony and other evidence in the case? The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe that person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not be influenced in any way by his decision. No juror should ever be concerned that the defendant did not take the witness stand to give testimony in the case. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to: 1, whether the defendant made the statement, whether when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, the case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. 3, the case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. The verdict form is as follows, and I will read it to you. In the Circuit Court of the 20th Judicial Circuit in and for Lee County, Florida, criminal action, State of Florida versus Wade Wilson, case number 19 CF 568, jury verdict form, penalty phase. We, the jury, find as follows as to the defendant, Wade Wilson, in this case. As to count 1, first-degree murder, Christine Melton. A, aggravating factors. Check either yes or no to each. 1, we, the jury, unanimously find that the state has established beyond a reasonable doubt that Wade Wilson was previously convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation. Yes, no. 2, we, the jury, unanimously find that the state has established beyond a reasonable doubt that Wade Wilson was previously convicted of another capital felony or of a felony involving the use or threat of violence to the person. Yes, no. 3, we, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was especially heinous, atrocious, or cruel. Yes, no. 4, we, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes, no. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations as to this count. If you, the jury, answered yes to any aggravating factor listed, proceed to section B. B, jury recommendation. If fewer than 8 jurors was previously convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation. Yes, no. 2, we, the jury, unanimously find that the state has established beyond a reasonable doubt that Wade Wilson was previously convicted of another capital felony or of a felony involving the use or threat of violence to the person. Yes, no. 3, we, the jury, unanimously find the state has established beyond a reasonable doubt that the first-degree murder was especially heinous, atrocious, or cruel. Yes, no. 4, we, the jury, unanimously find the state has established beyond a reasonable doubt that the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes, no. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations as to this count. If you, the jury, answered yes to any aggravating factor listed, proceed to section B. B, jury recommendation. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Wade Wilson should be sentenced to life in prison without the possibility of parole or death. Check only 1. We, the jury, find Wade Wilson should be sentenced to life in prison without the possibility of parole. We, the jury, find by a vote of blank to blank that Wade Wilson should be sentenced to death. Dated blank, place for the date and for the foreperson to sign and place their juror identification number. Submitting case to the jury. In just a few moments, you will be taken to the jury room by the bailiff. When you have reached decisions in conformity with these instructions, the appropriate form should be signed and dated by your foreperson. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case, and you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. Rules do not allow you to bring those phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. During this trial, items are received into evidence as in exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate, or if you wish to see any exhibit not sent back into the jury room, please request that in writing. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one decision over another. If you need to communicate with me, send a note through the bailiff, signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. With that, ladies and gentlemen, I'll let the bailiff escort you back and you can begin your deliberations. Let the record reflect jury states of the court. Are any objections to the instructions as read other than the ones previously stated?
No.
Okay. All right. Please be seated. Let me, there was one thing. There's another correction. Actually, there were a couple, but that's fine. On pages 7 and 8, you're going back and forth on how to spell Diana Ruiz. Sometimes it's spelled Diane, sometimes it's spelled Diana.
Whatever reason, Judge, I made those changes and it's not saving, but I will. You said 7 and 8, Judge?
7 and 8. Now, how are you spelling it? How is the correct way?
D-I-A-N-E.
Okay, then it is correct on page 7, and on page 8 are correct. Then I believe then somewhere else that it's not correct.
Judge, with Mr. Shirley present.
You may, yes, yes. I believe it's in the verdict form. You have, as the heading is Diana, D-I-A-N-A. And then, of course, it says as account for first degree murder, Diana Ruiz.
Okay, Judge, I found on page 7 reference to Diana, which it should be Diane.
Okay.
And it didn't change to the verdict form.
The page 3 of the verdict form.
Yes, sir.
Okay. You changed it where it says unnecessarily tortious.
Yes, Your
Okay.
Honor. Page 7.
Is that page 7? All right, any objection? You just changed on page 7 the spelling of the Diane Ruiz.
That's fine.
All right. So it was spelled differently on top of the page as opposed to lower on the page.
Yes.
And then you changed the verdict form where it also was misspelled. All right, these are the instructions that will go back. Just make sure, just hand it to the state defense real quick one last time. There's the exhibits.